Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the December 4th, 2025 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman. Sitting to my right, Justice Andrew D'Angelo, and to my left, Justice Jennifer Allen. We have 4 cases on today. Usual appeals court rules are in effect. That means that each side has 15 minutes to make its presentation and there is no rebuttal. We use the red light in this court, which means at the end of 15 minutes, the red light will go off, which means at that point, you must, I repeat, must stop your argument. Should we wish to give you additional time in our discretion, we will do so. On occasion, you will see the judges looking down at their iPads. That is not because we are checking the Bruins score. That is not because we're reading the funnies. It is because we have your briefs and the entire record on our iPads, and we are merely checking your representations, the record, or the case law in real time. You see if there are any further business matters from my colleagues. No? Then we will call our first case. Docket 24P418, Commonwealth versus RINTALA. Attorney Ramos. Nice to see you, counsel. Apparently I dated myself with a reference to the funnies, but those of you over the age of 50 will understand and appreciate it.
Good morning, Your Honors. May it please the Court, Melissa Ramos on behalf of CARA RINTALA, who's watching today along with her family. I hope to address the first issue, the Batson issue, and then, time permitting, move on to the extraneous influence issue. JEB says that gender, like race, is an unconstitutional proxy for juror competence and impartiality. And it makes clear that each individual juror has the right to be evaluated in a non-discriminatory way. Here, the record is that, 1, the Commonwealth struck Juror 40 because of her workload, even though she was confident she could manage everything, and her age and lack of life experience, even though she was very accomplished and very intelligent. The record also shows that the judge didn't agree with the Commonwealth's reasons, but still allowed the strike. The judge should not have allowed the strike. The prosecutor's reasons were not genuine, and they were pretexts for gender discrimination. Looking at the totality of the relevant facts, the record did not support the claims that the Commonwealth made about Juror 40, and the judge was too deferential in finding that this was the genuine reason for the strike.
So let's take a step back. My recollection, I just want to make sure that I understand the context of this issue as it was raised at trial.
Sure.
The Commonwealth, the state of play was as follows. The Commonwealth had made 5 peremptory challenges initially, all of white males. Is that correct?
I believe so, yes. And
trial counsel for the defendant raised a source challenge.
Yes, on the previous day.
Right. The next challenge to which, by the Commonwealth, to which there was an objection was of this juror, correct?
Yes.
Okay. And at trial counsel made that challenge on the basis of age, race, and gender. Is that correct?
So trial counsel objected to the use of age, but made the Bats and Sores challenge on the basis of gender and race. There was a little bit of confusion kind of in the record.
My recollection is she specifically said twice, and age, Judge.
On page... So trial counsel talks about how she always objects to age when it's used as a reason because she says, you know, if the commissioner says you can serve, then you should be able to serve. And then kind of makes a misstatement that says age and gender, and then says something along the lines of, I'm objecting to age, but the basis for the challenge is race and gender. Pardon me for...
Okay, Volume 2, page 225, just the challenge was age and gender. And then she says, and race, Judge, I objected to age.
Yes, so she's trying to clarify, she just made a misstatement that,
Okay, so regardless,
Yes, yes.
my point is, at trial, they objected on the basis of potentially age, but also race and gender.
yes,
Okay. Your argument today focuses solely on gender, is that correct?
yes.
Okay. And my only other question for context is, my understanding is that defense counsel at trial made 3 peremptory challenges,
I believe so.
all of women?
Defense counsel?
Yeah, defense counsel.
I believe so. I'd have to double check the record.
Okay. I'm sorry for the interruption. Go ahead.
No, please. And so I want to get back to kind of just talking about what factors here show that age was a pretext for gender discrimination. And I also just want to be clear that the argument here is not that age is a protected class. We know that the case law says so. The argument is that the justification was not genuine, that it was based on gender stereotypes and as pretext for gender discrimination. So the factors, some of the factors that tell us that this was pretext, that age was pretext. First, the research demonstrates that Batson has not done very much to increase jury diversity, and that age is often a reason used for strikes. And then we can look to the way that the prosecutor responded to the Batson challenge, saying twice that age was not a protected class and that it was a proper reason for the strike. So by commenting on age in this way, essentially signaling this is how I protect the strike from scrutiny.
Or it could be that the prosecutor really was using age as a reason to strike the juror. If that is the reason why, I believe it's a he keeps saying that, maybe it's because that is the reason why he struck it, and then only the judge has to make a finding that that was genuine and material.
So there could be an inference that age is the genuine reason, but with all of the factors together, I think that there's an inference that that language and that assertion is indicating that age is being used as a way to insulate the strike from further
How
scrutiny.
are we in a better position to make that determination than the trial judge who is observing the parties, the lawyers, the prospective jurors, and is doing so in real time and can observe everything that's going on as opposed to a stale transcript?
Sure. So the strike here, allowing the strike here was an abuse of discretion because when Benoit talks about conducting a meaningful consideration on whether the challenge has a substantive basis or is linked to discriminatory intent. And the judge's findings actually only make a cursory mention of age and only repeat what the Commonwealth has said about Juror 40's course schedule. So to the extent that the judge's reasoning is based on the Commonwealth's assertion of fact that's not supported by the record, it's an abuse of discretion. So there actually isn't a meaningful consideration that's undertaken because the judge could have done more to kind of either uncover these gender stereotypes, like bringing the juror back in for questioning, which the judge had done previously when the Commonwealth hadn't followed up on reasons that they then tried to use to remove a juror. And specifically when defense counsel brought up Juror 9, the 23-year-old Hispanic male, who arguably had more conflict in his schedule because of the time that every day he needed to be the sole soccer coach at 4 p.m. The judge could have inquired why that scheduling issue wasn't of concern to the Commonwealth, but Juror 40 scheduling issue was.
The prosecutor specifically pointed to the juror's age and saying, I don't believe the juror has enough life experience. If this juror had been selected, and this is the question, would have been the youngest juror on the jury, correct?
Yes.
So even though the trial judge and maybe the three of us agree that 20 versus 23 is not a big difference, it is in fact a difference. It's 3 years. Why isn't that alone potentially genuine material?
Because here, it's not just exclusively about the number. If the Commonwealth had made some kind of assertion that that their strategy was to strike every juror under a certain age, then maybe we'd have a different case. But when we look at the comparison between Juror 9 and Juror 40, they had answers that were very similar in many respects. And there's no one-to-one comparison. It's not realistic, and it's not what the law tells us to do. We are to look at an otherwise similar juror who's not in the protected class, and that is a factor on whether the reason for the strike was genuine. So their answers were very similar in a lot of respects, their status as students, their class and schedule burden, and they both answered their questions very credibly and quickly. And so, as I said, Juror 9 had more conflict in his schedule. So when we look at kind of the basis for invidious discrimination, that can be an unconscious bias, we can look to gender stereotypes. And so a similarly situated male juror is looked at as competent and respected and able to engage with a murder trial in a certain way.
Well, not according to trial counsel. Trial counsel said that defense counsel said the prosecutor was challenging all the white males based on their race.
Sure.
I mean, it seemed like the prosecutor couldn't get it right from defense counsel's perspective. No matter whom they challenged, it was seemingly the subject of a source challenge.
And I don't think that that should be looked at as an opportunity to manipulate the process. Each juror has the right to be evaluated individually and not based on group stereotypes.
Isn't that exactly what defense counsel did here? She did the reverse. She's saying initially, he's trying to get rid of all of this gender. And then on the follow-up, when the prosecutor uses a challenge on the other gender, she flips and says, well, now it's that gender. So it seems to me the source challenge here, you have to look at the history of not only who's selected, but who's being challenged here. And isn't that exactly what the trial judge did here?
So we can harbor biases against any group at any time because of these stereotypes. So when someone comes before us and we believe that they fit into a stereotype that goes with their group, we can harbor biases against them. So it's not, I don't want any men on the jury and I don't want any women on the jury. That's not what we're looking at. We're looking at these little elements of group stereotypes that impact our ability to treat the person in front of us fairly. So as I said before, and mentioned in the brief, there are stereotypes about women being less competent, more emotional, and having less of an ability to engage with the type of material at a murder trial. But the male juror gets the benefit of being competent and respected and able to less emotionally engage with the content. So when we look at Juror 40, we can see that she was confident and she was credible, but the reasons for striking her were based on these discrete stereotypes about women being less competent, because while there is an age difference between Juror 40 and Juror 9, they are so substantially similar in what the record reflects as their experiences. The Commonwealth is essentially faulting Juror 40 for not having anything to disclose on the questionnaire that could have compromised her ability to be fair and impartial, in the way that, you know, Juror 9 talked about the lawsuit that his parents had filed when he was a child based on an allergic reaction. And so when asked to disclose something about her parents' divorce, Juror 40 talked about, she even made mention of her age. She said, I know I'm young, but I'm not so young to know that everybody's situation isn't unique. That is a very reasoned, a very mature answer. And so if life experience was something that the Commonwealth wanted to probe more of, they could have done that. Only the judge and defense counsel brought up the juror's schedule to ensure that it was something she could manage, and she did not waver in her responses that she could manage the schedule, in the same way that Juror 40 said, yeah, I'm a soccer coach in the evenings, but I can probably make that work. She said, my classes are all recorded, my professors are lenient, my schedule's relaxed. I can make up classes, in the evenings and on the weekends. I have time to do that, and my professors might even like that I'm doing it. So I think that there are substantially similar, the jurors are substantially similar in that
Let's-
their age is not so much of a difference.
Before you run out of time, I'd like to talk about the extraneous influence
Absolutely.
issue. Are
So-
you arguing structural error here? In other words, to rephrase it, are you arguing that sometimes the prejudice due to the nature of the extraneous influence is so large or consuming that just as a matter of law, a mistrial must be granted, which I think is tantamount to structural error? Or are you arguing something different?
I would not say that I'm arguing structural error. I'm saying that in a fact-specific inquiry, which a lot of these extraneous influence cases are about, that this case is exceptional in that there was a lot of procedural history and there were crumbs that were left, for better or worse, throughout the trial.
Counsel, as a follow-up to Justice Neyman, because that was exactly what I wanted to raise, which is, besides a mistrial in this, was there anything the trial judge could have done differently that would have cured the prejudice?
No. A mistrial at that point was the only thing, because this level of information, looked at in context of the entire trial, was so prejudicial to diminish the presumption of innocence, because this jury, essentially by what they learned that another jury with their same task had already found CARA guilty beyond a reasonable doubt. And so
You made that assertion in your brief, and I couldn't find the evidence to support that. You're making that purely inferentially, aren't you, based on the fact that they learned that she was in custody, correct?
So it wasn't just custody, it was incarceration based on the outcome of a prior trial. The only prior trial that was spoken about was this one that happened, 3 previous times, because even though they learned about her,
Your time is
my
up.
time is up.
But please answer the question.
Sure.
We may have additional questions for you.
They had learned about the assault and battery arrest, but they had also learned that that was dismissed. So they only learned about this trial and her incarceration for this trial, and that another jury had already done the job that they were tasked to do.
So are you arguing that the voir dire here, the individual voir dire of all the jurors, was just irrelevant?
Not irrelevant, but could not cure the prejudice.
Well, then as a matter of law, it is insufficient, or just as a matter of fact, or both?
The process by which the judge underwent, which was appropriate based on the case law, was still insufficient to cure the prejudice here, because it diminished the burden of proof. The information diminished the burden of proof and the presumption of innocence far too far.
So
Go ahead.
the voir dire then was basically irrelevant, because in your position, as soon as the jurors heard that information, it was irrelevant what the jurors said during the voir dire, because the judge just should have granted a mistrial at that point, right? Because they all said they could basically put it out of their minds and just base it on the evidence. So no matter what those jurors said in your position, a mistrial should have been granted.
In the way that you're framing it, sure, yes, irrelevance, but I'm not trying to argue that the process should not have been engaged with, that there was anything improper about the process. Here, it's just that the prejudice was far too great for anything to cure it.
I have one final question. It's on the third issue.
Okay.
You are making the argument that, well, let's cut to the chase. You cite the Alvarez case.
Yes.
Alvarez, Chief Justice Gantz said, in a case where there is I'm paraphrasing this part, in a case where there's a Bowden defense, but Bowden instruction has not been given, quote, it would be prudent to omit from the instructions the sentence, you are not to engage in guesswork about unanswered questions that remain in your mind. In our case, there was a Bowden instruction given. So how do you get around that?
So I think the logic, as I argue in the brief and the reply, the logic between the two actually works similarly. So where the Bowdoin instruction was not given, but counsel still made a Bowdoin argument in closing that the instruction about speculation undercuts that Bowdoin argument that defense counsel then makes.
So why do you think Chief Justice Gantz limited his admonition to cases in which a Bowdoin or Bowdoin instruction has not been given?
Those were the facts that were part of the case, and so, structuring the decision to be kind of what was in front of them. But, the Bowdoin instruction is not required, although, it says that it's preferable to give it. It's not required, and so I don't think that there have been many cases to go up where the Bowdoin instruction was given, but I think this is a really good example of how the Bowdoin instruction plus the instructions on speculation really conflict and make it hard for the jury to know their job.
Let me see if there are further questions. Nope, well argued, counsel.
Thank you.
We will hear from the Commonwealth.
Good morning.
Morning.
May it please the Court, Cynthia Von Flatern, Assistant District Attorney, Northwestern District for the Commonwealth. Seated with me is First Assistant District Attorney Stephen Gagney, who was trial counsel for the Commonwealth. The Commonwealth would ask that the verdict of the jury finding the defendant guilty of voluntary manslaughter be affirmed today. With respect to the first issue, I think the record is clear that the judge and the parties carefully interviewed each potential juror. On the first day, the Commonwealth exercised peremptory challenges on several males. They happened to be white males. And then in attempting to exercise a third challenge of a male, there was a Batson source challenge to that male. The prosecutor gave the reason, and there was a contest of that challenge, and the judge actually found that the reason was not adequate, and the person was kept on the jury. So then we go to the next day. There is a challenge to, well, first we have that graduate student that is not challenged. He is a graduate student taking 2 classes. He said his schedule was not challenging. He was doing other things, and he was clear about that, juggling being a JV soccer coach and also being working at UMass with pre-med students. So there was no challenge. The Commonwealth had a right not to have to challenge that juror. This is peremptory.
Why didn't he challenge that? I mean, his argument to the judge was, Judge, in our experience, we think young jurors are they don't have life experience. We have to deal with people here who can make big decisions based on having families and experience and life challenges.
I would say,
and then he challenges the 20-year-old, but he doesn't challenge the 23-year-old. Both students, both with very similar backgrounds. I mean, why isn't that answer insufficient in terms of the genuine prong of the analysis?
I would say two things to answer that question, Your Honor. First, as the prosecutor indicated, he saw them as being different. There is a 3-year age difference. One is an undergraduate student. Number 40 is an undergraduate student, and juror number 9 was a graduate student. And there are 3 years, and I would submit that the case law and the research, I'm talking about Dichenko and Mattis, has already supported that there is a difference between a 23-year-old and an 18 to 20-year-old. That's brain development.
There may be in some circumstances, but the reason here was age equates to not mature. I would suggest that's exactly what he said, maturity and life experience.
Inexperience, yeah, thank you.
This 20-year-old, contrary to maybe what the 23-year-old had, seemed to have a lot of life experience, had been many places, had done a lot of different things. So when you use that part of the equation, why wasn't it an abuse of discretion to say they're basically the same?
Well, and again, the standard of review is abuse of discretion, and so the judge did have broad discussion, and the prosecutor brought up brought up these differences. This young woman had spoke very well, and she had experience. She had lived in Miami and been on the crew team and so forth, but she didn't have the life experience like having a family or being married or having a lot of, she didn't have any jobs.
Did the 23-year-old, was there evidence in the record that he was married, had children, or any of those things?
Not that he was married and had children, but he was working. And this individual was not working. And I would say, and the second part of my answer would be that we have the law that allows parties to exercise peremptory challenges, not when they're based on a protected class, but people, prosecutors and defendants, parties can still exercise a peremptory challenge. And here, the Commonwealth would submit that the information or the answer was that this is specific to this juror, and that's what the judge found in his discretion.
You raised in your brief and just now the Diachenko cases, which that line of cases essentially talks about the brain science and brain development of juveniles and how, 21-year-olds still are undergoing, for lack of a better term, brain growth. Their brains aren't fully developed, and therefore their conduct is less predictable and less etched in stone, for lack of a better term. Has Diachenko ever been applied, or that line of cases, in any context outside of juvenile court sentencing or juvenile court issues?
Well, I think with respect to adult court, when an individual is 18, 19, or 20, we recognize that. And this is a footnote, because I think it's interesting that you had a 20-year-old and you had a 23-year-old. So when you're looking at the genuineness of the challenge, which is what we are focused on, then I think that supports the genuineness of the challenge. And I think
I guess what I'm asking in my very poorly phrased question, let me give another stab at it. Have we ever applied the Diachenko line of cases in a context like this?
I don't believe so, Your Honor, and I don't think that it is necessary to do in this case because I think that what we are looking at is the judge's use of discretion, appropriate use of discretion, and his finding that the challenge was genuine and it was adequate in this particular case.
I'd like you to address the extraneous information issue. And in particular, have you ever seen a case where, well, first of all, how many jurors were exposed to the extraneous information? Do we know?
The record would show that there were two jurors. There was the female juror who said something, and that was the basis of the note that the foreperson wrote. And then two other jurors said that he had said something. Well, and the female juror who said something said that this male juror, I believe it's number 18 in seat number 1, said something. And it looks like, and most of the jurors did not hear that second juror say anything.
The foreperson must have also known because the foreperson wrote the note, right?
She wrote the note about what the first juror, the female juror, had said.
So was the entire jury exposed to what that first female juror said?
It appears so. When the judge conducted this careful colloquy of all of the jurors, and all of them said that they didn't have the prior information about the defendant being incarcerated, but the note was read to them, so if they didn't hear it during deliberation, they heard it when the judge inquired of them.
So let me ask the obvious follow-up, which is, can you cite a case, a published case, where in Massachusetts, where this many jurors heard this type of extraneous information and it was held not to be an abuse of discretion to deny a mistrial? I
believe the Sanchez case, Your Honor, was similar, and that was a first-degree murder, where the juror in deliberations knew quite a bit about the defendant, and then and said something about thought that the defendant could have done it, and she knew a third party who was involved, and because that person was dating her niece, so it was quite prejudicial.
Was she aware in that case that the same defendant had already done time for the same offense?
I'm sorry, I might be mixing up the two. There is a case, and I think it's the Sanchez case, where they were aware that there had been a previous conviction of murder, of first-degree murder. So there is a case.
On the same case?
I believe so.
Okay.
I believe so. And
You mean Santiago, I think.
Santiago, I'm sorry. You know, I think the CAMERA case is the most instructive on this issue, because they are clear that this kind of problem that would arise is remediable. And they take pains to say that when you have a careful colloquy by the judge, and you also have jurors that are found to be very credible and can assure the judge that they can be that they can put this information aside. You know, if there was a juror that couldn't put it aside, there was another alternate that could have been used in this case. There were two jurors, the first one who was the basis of the note, and then the one that made some comments. So both of those were out, and there was another alternate that could have been used here. But one thing that they talk about in CAMERA, they talk about the Fiddler case, where if this was a motion for new trial and you were going back and then the court becomes aware of some extraneous influence on the jury that has been dismissed, and there's no way to get those jurors back, well, then the court has to consider what effect this would have on the average jurors. But here, you don't need to do that. We have the jurors here, and the judge conducted a colloquy with each and every one of them. So respectfully, for a reviewing court to then say, to reject all of that work and all of the assurances by these folks that have sat in that courtroom for weeks, that they assuring the judge that they can be impartial and disregard that extraneous information, I think I don't think the case law supports that.
Is there any kind of information that a jury can get outside information that a jury can get that is just so prejudicial that no matter what they say, it's too much?
I don't know. That has been asked as a hypothetical. I think there might be sometimes, if it was a case, and I think mostly there would be a mistrial if in the courtroom there was a defendant attacking the judge or something like that. I think that would be so prejudicial.
Information specific to the case about what happened prior or afterwards.
Yeah.
Because that is what defense or appellate counsel is inferring, that this is just so bad that nothing can ameliorate the problem.
I would submit that our whole system is based on the jurors accepting and having people that can act as jurors who will accept the judge's instructions. And that includes disregarding extraneous information, whether it's something that a witness said on the stand or something that they heard otherwise. So I cannot think of a case where we would have that kind of prejudice, which would result basically in structural error and the need to overturn the case. So I'm sure there would be a case, but I can't think of one where a careful colloquy could not override the extraneous information. That was not that, in the course of the whole thing, was not that great. I would also say, with respect to one of the jurors in seat number 6, and there were a couple of others too, and the judge pointed this out, that they had, when the jurors were questioned, some of them had information, including that there had been a prior trial, and granted, not to the extent of prior incarceration, but you know, the whole system was based on, having heard something, can you disregard that and listen to my instruction and listen to the evidence?
With respect to the Bowden issue, I know counsel calls it Bowden, and I've heard it called both, but I've always been taught it was Bowden, so I'm going to say Bowden. Why did the Supreme Judicial Court limit its admonition in Alvarez to cases in which a Bowden instruction is not given?
I think, Your Honor, because when it is not given, they have this information or they may have heard evidence that some tests were not done or something wasn't followed up on, and they may think to themselves, gee, I don't know what to do with that. And then for there to be an instruction on speculation, that puts the jury in a hard place. But when you have the instruction, then the jury is told how they can consider that evidence. They can consider it that the investigation could have been sloppy, or that there could be bias on the part of the police. So they're specifically told how they can process that information.
Do the instructions conflict?
Do the instructions conflict? I think that they do not, because I think that encouraging or saying to the jury that they are allowed to speculate still is not allowed, even with a Bowden, that you can, that the jury can consider Bowden and can consider a claim that an investigation was not complete or tests were not done without having to speculate.
I'm less concerned about the speculation language than the part of the instruction that says you are not to decide this case on the basis of speculation, suspicion, or unanswered questions in your mind. Where does that language come from? Unanswered questions in your mind.
Unanswered questions in your mind. Well, I think that just goes to, the jury saying, well, I didn't hear very much about the victim's, a prior relationship, so perhaps that person did it. Well, that would not be appropriate. And I think it's similar to speculation.
If the jurors have unanswered questions in their mind, doesn't that directly go to whether the Commonwealth has proven the case beyond a reasonable doubt?
Well, and the jury is instructed on, they were instructed properly on the burden that the Commonwealth had several times.
But I guess
So-
that's where Justice Neyman is asking the question, doesn't that contradict it? If the jurors have unanswered questions in their mind, that might be tantamount to a beyond a reasonable doubt, but the judge is saying, don't consider that.
Well, I think the way I would interpret unanswered questions is that you go to the next step to speculation, because they have been, instructed carefully on the burden of proof here and what their responsibility is, that they must find beyond a reasonable doubt.
Okay, and we're going to have to leave it right there. I'd like to acknowledge the outstanding briefing, the excellent oral arguments, and the cases submitted. Thank you both.
Thank you, Your Honor.
Calling our next case, docket 24P935, Commonwealth v. PIRES or PIRES. I am confident counsel will instruct me on the correct pronunciation. Hang on one second, counsel, before you begin.
Of course. It's PIRES.
Attorney Zindrowski, good morning.
Morning. Good morning. May it please the court. I'm here today on behalf of LEVON PIRES. I think I'm going to try to focus on my first two arguments today, but
Counsel, could you move the microphone just up? There we go. Thank you.
This is better. It's always a problem. Okay. So I'm going to focus on my first two, and I'm going to start with the motion to suppress, because I think that might be a little bit more complicated. So I'm going to start that argument with the motion judge's findings, that the motion judge specifically found that after Mr. PIRES ran from the officer, he at some point pulled out a gun. The officer saw the gun, yelled out, he's got a gun, got on the radio to his fellow officers, tell them about the situation, and then the motion judge found at that point he began to run after Mr. PIRES.
Counsel, let's assume for a second that the officer said, "What's up?" I can't remember what's up.
Yeah.
Defendant starts running, and at that point, the officer starts running after him.
Okay.
That's not a seizure, is it?
I think with Commonwealth versus Palmer that came out after I did the brief for this case, but I think that might be a seizure there, where the seizure in Palmer began when the police pursued the defendant.
Police, plural, in
Well,
Palmer, right? There
right.
was more than one coming from different directions in Palmer, correct?
Correct, yes.
And in, sorry, go ahead. Well, I was going to say, and in Palmer, there was evidence that the defendant was aware that the police were pursuing him. Here, my understanding of the record, I'm sure you'll correct me if I'm wrong, is that the judge found that the defendant took off, never looked back, and there was no evidence in the record that he ever looked back or was aware that an officer at some point started to pursue him.
This would be correct. He did not look back once he started running.
So
That's what the
under
record-
Commonwealth versus Franklin, which is 456 Mass at page 819, doesn't that mean that it's not technically a seizure until at some point he is aware that he is being chased?
I think, to me, Franklin was kind of turned on the fact that the police didn't announce themselves in any sense to Franklin. They just kind of started chasing. They didn't make any statements to the person, the defendant there. And so the defendant saw the police car and just took off running before anything else happened. And then the police got out and followed him. But they didn't make any sort of statement to him. And so I think that that statement of, what's up, what's good, directed, Mr. Pires would have been aware that the police were, looking at him, that they were focused on him. And I think that the distances weren't particularly great. There's a map, it's a half block in a dense, residential neighborhood. So I think that it's inferable that he would be aware that a police officer would be chasing him.
So I want to make sure that I'm clear on your position. Your position is that because the defendant knew he was a police officer, that as soon as the one police officer started chasing him, that's when the seizure occurred.
Yes, with the additional facts of that there was, another officer in the car, that they pulled up on the road, kind of on the street he was on, and then they're chasing him in the direction, presumably.
Even if there is no evidence in the record that he was aware that he was being pursued?
I think it's inferable from the record is what I would say, that the distances are close, and just the only thing that we have is he didn't look back. And so I'm not sure how one would necessarily be aware, but within the close circumstance and the close distance, I think
I
that
turned and
that's
saw
inferable.
them, I heard footsteps. A friend said, "You better move it, they're after you," something.
Right, well, but the defendant didn't testify, so I think that's going to
Well, the
be...
police officer could have testified that as I was running after him, the defendant turned and looked at me. There's no evidence of that.
No, there wasn't. That he didn't, he just ran and did not look back.
Would you agree that once the defendant took out the gun and the officer saw the gun, it was permissible to seize him at that point?
Yes. Once he takes out what he thinks is a firearm, I think at that point, then there would be a permissible seizure. So I think the seizure has to happen when the pursuit begins, for my argument to hold water there.
So Franklin, this is 456 Mass, at page 822 says,
822.
following a person presumably at a rate of speed sufficient to keep him in sight does not amount to a seizure, absent some additional assertion or authority by direct verbal communication, quote, stop, or otherwise blocking use of flashers. And that they're citing Commonwealth versus Grandison for that proposition. Is that still an accurate statement of law?
It seems like this is a little bit muddled with Palmer and what's going on. I think there's some sort of issue going on there. But I think generally it is. I think in this case it was the attention being directed towards the defendant. And so in Franklin there wasn't any sort of attention, and the fact that the road was blocked, that he would have to go away from the police when there's more than one officer on the scene.
So your best cases here for this issue are Palmer and anything else?
I think Evelyn as well. I think sort of stands for that proposition of this statement, or the attention being directed towards the defendant is kind of a necessary part of that. So
You want us to go a little further than that and say that our holding should be running, I won't even say chasing, running after the defendant when the defendant knows he's a police officer and knows that there's one other police officer in the car, that's enough for a seizure.
And that there's been attention, that we know that it's probably not a friendly chat, that the police are pulling up, coming out of the car, standing in front of it, saying, hey, what's going on, defendant.
Well, it's pretty rare that any time a police officer wants to talk to somebody, it's just a friendly gesture.
Exactly.
So again, I guess I'm trying to figure out where you want us to draw the line, because I don't think the line has been drawn yet that the chase alone is enough.
I think it's the chase alone plus the statements directing the attention at the defendant. So same with Palmer, where it was, the detective there saying, hey, you want to answer some questions, or, speaking to the defendant in a way just to get that defendant's attention that, we know that we are looking at you specifically, plus the pursuit.
I guess the problem I'm having with that is what the officer said makes the defendant aware of that. I mean, he basically says, I'm paraphrasing, what's up?
Yeah.
I mean, what else could an officer say that doesn't direct the attention? How are you? What's the weather like? I mean...
Right. Well, I think it's that plus the pursuit. So it's both those things combined, really. It's not just saying, what's good, what's up. It's that plus running basically means, well, it wasn't just, a friendly greeting.
If you could turn to the trial issue. I want to know, why do you believe that the prior shooting has no relevance, or are you saying that it's relevant, but it's outweighed by the substantial prejudice?
I don't know that it has much relevance, because there's no evidence that he knew about the shooting. And so, to the limited extent that it has relevance, it must be to the police officers who were aware that there was a shooting. But they don't give us much either. They are aware that there was a shooting, but they don't connect that to anything else in particular.
Doesn't that cut against your argument about prejudice, though? If there's no connection that the defendant had anything to do with the shooting, and there's no evidence of that introduced at the trial, why should we infer that the jury did that?
I think for the prejudice, it's an implication. It's a big implication is what my response would be. And you can look at how the prosecutor argued in closing, where we have the detective monitoring Snapchat. He sees Mr. Pires post up his video saying, that he doesn't leave home without his firearm. And then we also happen to know that there was a shooting the night before. But the order that it was brought up in would be Mr. Pires is saying he's got a gun, and then there was a shooting the night before, someone was shot. So a more serious crime. So there's just sort of leaving that evidence hanging out there, just without any connection to Mr. Pires, I think is where the prejudice comes in. And the
limiting instruction have cured any problem? Because no one asked for it.
Right.
No one gave it. It was argued for that reason, that this is basically why the police officers were looking, blah, blah, blah. Would a limiting instruction have cured any problem?
I mean, I suppose a limiting instruction might cure it without, just off the top of my head. Let's see. But again, it just wasn't connected to anything else at trial. And I'm not sure that it's probative of much either, that the police were taking firearms extra seriously that day. But the testimony from the detective who monitors Snapchat was he does this as part of his job already. And it's very helpful. It's a very good tool for him. They like using that to investigate. And so I don't know that they were looking at it extra hard because of this evidence that was unconnected is particularly probative of anything.
Does it put into significance the Snapchat post itself that the defendant is keeping a gun with him? perhaps because of the shooting that was very close to the area where he lived? Not that he was involved in it,
Right.
but that's why he was going to carry a gun?
I think there needed to be some sort of, sliver of evidence that would show that he was aware that there was a shooting. Because just the same neighborhood wouldn't be quite enough to show that he knew, that had happened. And so without any, he really doesn't have any connection to it with the evidence at trial or how it came in. Let's take a quick look. I think that basically covers all the points I wanted to cover. If there are no further questions, I'm happy to rest on my brief.
Seeing none, thank you very much.
Thank you.
Arguments much appreciated, and we will hear from the Commonwealth.
Good morning, Your Honors. May it please the Court. Christopher Amaral for the Commonwealth.
I'm going to have to ask you to speak
Oh,
up,
sorry.
please. That's okay.
So I'd like to address issue 2 briefly. So since defense counsel has brought up
I'm going to have to ask you again. I really need you to speak up. Sorry, the fan's on, and I'm getting older. I can't hear as
apologize.
well as
Sorry.
I used to.
Since defense counsel has brought up Commonwealth versus Palmer, I think quoting Justice Ditkoff directly in his concurrence, he says, "It is settled law that police officers do not seize a running defendant merely by running after the defendant. One does not need police authority to follow someone, even someone who is running. Instead, a seizure occurs when pursuit is accompanied by a command to stop or by other actions communicating the use of police authority to require the defendant to stop." So,
Is there anything in the majority opinion that contradicts Justice Ditkoff's view in the concurrence?
so the majority or the plurality in that opinion.
Plurality, yeah, well said.
So the plurality in that opinion, the major sticking point in my mind is the fact that there's multiple officers coming in, I think in multiple different directions. So it's extremely clear that this person is not in a position to just walk away. If I see 5 cops coming this way, 5 cops coming this way, and they're all coming at me, it's pretty clear, okay, there's no stop, but it's pretty clear.
Was there evidence in Palmer that and Palmer doesn't necessarily turn on the moment of seizure anyway,
Right.
depending on which justice you ask.
Right.
But was there evidence in Palmer that the defendant knew he was being pursued,
I think
or was objectively aware of such?
at a certain point, he was objectively aware before, the cops converge on him, that there's a point where he, understands that he's, that the cops are coming and at least non-verbally communicating that, you're not allowed to leave. In this case, we don't have any of that. We don't have the flashers that we have in some of these other cases. We don't have a stop. What we have is a police officer comes out of the car and says, as Your Honor articulated kind of very casually, like, "What's up?" This isn't a, "Hey, I want to talk to you." This is a, "Hey, he says, "What's good, LEVON?" As in, like, "Hey, I've seen you before. What's up? What's up?" So that, this case law on the fact that just a police officer coming up to somebody saying, "Hi, what's up? What's the time?" That's not a seizure. That can't be the point of the stop. Yes.
Let me go to something Justice Neyman may be suggesting, I don't know. In this day and age, if the defendant becomes aware that a police officer is chasing him, wouldn't a reasonable person in that position believe that they're going to be stopped? That that's why they're being chased? It's not just, they're going on a road race? And isn't that sort of where the rubber meets the road for our finding is a reasonable person in the defendant's position, would they believe they're free to leave? Police officers chasing him. How do we square that?
I think, well, at least in terms of these facts, thinking about different cases like Mata and Franklin, and I think old case, Commonwealth versus Battle, where they're following him, following the defendant. I think, if I see, I might get nervous if I'm walking down the street, I see a cop, turn the corner at the same time I might think, oh.
Nervous meaning following, walking.
Following, walking.
You'd be pretty
or
darn nervous if a police officer starts running after you, right?
I suppose.
And I guess I'm trying to square that with what, in this day and age, a reasonable person, because that's the standard.
Right.
A reasonable person, and again, to use Justice Neyman's language, knows, and maybe that's where this case differs, knows the police officer is chasing after him.
Right.
Reasonable person believe they're free to leave. Police officer's just going to stop running. Call for backup.
I think it would depend. The problem with these cases is that it's so fact specific for any of these cases. I think in a general sense, I think if I'm running down the street and I've run, a quarter mile and the police officer is still running after me and hasn't said anything, I guess my brain could go in two different ways. He hasn't told me to stop, but yet he's still running after me, so I don't know which way. It could go either way.
Well, MATA tells us the free-to-leave standard is no longer the standard in Massachusetts. The standard's under MATA, which is whether an officer has, through words or conduct, objectively communicated that the officer would use his or her police power to coerce that person to stay.
Right.
So it's an objective test. So part of the objective test would obviously be what does the defendant know, or at least what is in the record from which we can infer that the defendant did or did not know what was happening.
Right. So using my, running down the street, the quarter mile, I guess in an objective sense, if a police officer has been running after me maybe for a quarter mile or for a long stretch of road, I guess that would be, you could say that that's an objective, there's something up, maybe there's something, he's not just on a brisk walk, or he's not just getting his exercise in and just happens to be following the same path, but turning to the facts in this case, I think Detective Alameda said the entire chase occurred in the span of, I think, 30 seconds or something like that. And so if you're thinking, okay, 30 seconds to go down the street and across and down the driveway, that's I guess a decent distance. But we're thinking the distance between when the defendant begins running and when the police officer sees the weapon, we're probably talking within a few seconds. So when we're saying running, it's not as if somebody is, it's not my quarter mile example of, oh, okay, well, now I'm really kind of getting nervous because a police officer has been chasing me for a while, and why is he doing this? This might have been, a few steps. It could have been, we're not exactly sure what the exact distance that could have been, but I think given that short amount of time, he could have just been, running and looking around the corner and saying, like, I think objectively, those few seconds probably come far short of what, like a show of authority of, like, this police officer definitely wants me to stop, especially after he's just kind of very calmly and colloquially said, hey, what's good, LEVON? If he had come up to him and was kind of maybe aggressive and said, hey, I want to talk to you for a second, or it said something a bit more aggressive, but there's no evidence of that. And then he takes off, and as your Honor noted earlier, that he's got his back to him, so saying that, he knows that he's being chased, I think all of those factors together don't rise to the level of this is a show of force.
Can we go to the prior shooting evidence?
Sure. So
let me ask you this question. Would you agree that that evidence was admitted for a limited purpose?
So I know that the prosecutor tells the judge, we want this in because we want to kind of say why these police officers are actually looking at, this person, or why this
Provides context.
It does provide context. It provides context, but I don't think context in the way that defense counsel is
Right, they say it's not a prior bad act, you say it's admissible for context, the police state of mind, what impelled them to, what their state of knowledge was as they proceeded. So, back to my question. Would you agree that that evidence was admitted for a limited purpose? The jury couldn't, for example, consider it as evidence that the defendant committed this crime because there was a prior shooting.
Correct, yes.
So back to my question, do you agree this was admitted for a limited purpose?
In that context, yeah, it's correct.
If it was admitted for a limited purpose, why on earth was there no limiting instruction?
For that, I would have to ask defense counsel why he didn't ask for one.
Or the prosecutor, who's
or
the
the
proponent of the evidence, and
Right.
therefore telling the jury, have the judge tell the jury what its purpose was for.
Correct.
And as a follow-up to Justice Neyman's question, since there was no limiting instruction, can't the jury use it for any purpose whatsoever?
I think without making speculations, so my I guess pushback on that is, in order to get to, I guess, where defense counsel is saying that this is going, where the jury looks at this and says, oh, there's a shooting, and so this person has the character, must have been involved in that somehow, and so he must be guilty of this, or he is, the jury in that case has to kind of make two big leaps. One, that the fact that there's a shooting, just standalone, okay, there's a shooting that happens, and then they're told that the police are, investigating. They have to infer from nothing except that this person is involved in this shooting, and then infer back that he, because he's involved in that shooting, he is also, guilty of this crime of carrying this
Your argument
weapon.
seems to be we don't know what the jury was thinking and what they did with this evidence, but we never know that. So Justice D'Angelo's question is, could that evidence have been considered by the jury for any purpose without a limiting instruction? And I think your answer should be yes, but I'm not going to tell you how to argue your case.
I mean, without a limiting instruction, I guess the jury were, the jury were free to, consider it for not just the purpose that the prosecutor gave to the judge when they were arguing to have that information in. The argument that I'm making in my brief, and I think without that information, what the jury are considering then at that point, if they're not told, okay, there's a shooting, right? What they're basically given is, okay, there's a police officer who, as part of his job, he's scrolling through Facebook, or, Snapchat. He's scrolling through Snapchat, social media, and he comes across a Snapchat, post, video.
Defendant says, I ain't going nowhere without my glizzy,
Without my
which he
glizzy,
takes to
correct.
mean a gun.
Right, exactly.
And so the prior shooting at least provides some context as to why the police were on high alert involving an
Exactly.
investigation in this neighborhood.
Correct.
Right. So why not give a limiting instruction that says, members of the jury, you're hearing this evidence to provide context and to explain what the state of police knowledge was at the time, but I instruct you, there is no evidence attaching the defendant to the shooting the prior day, and you may not consider it as such. You can only consider it for the limited purpose I already told you. I don't understand why that instruction wasn't given here. I understand it wasn't requested. But why wouldn't the prosecutor in a case like this, where the defendant is caught on videotape, with a gun, disposing it over a fence, why wouldn't the prosecutor just remind the judge, and why wouldn't the judge just give that instruction?
All right. I mean, I can't jump into I wasn't the trial prosecutor, unfortunately, so I don't know.
Understood.
I can't jump into the mind of why that wasn't given. I believe the standard instruction was given at the jury were told essentially, you can't speculate, you can't go beyond what the evidence tells you. So, I mean, in that sense, they were told, here's some evidence. It's not evidence that you can, you can't extrapolate, make these big leaps of logic. And I think that's what would have been required of the jury if they were considering that for the purpose that, that the defense counsel is.
They were told not to speculate.
Correct.
Why, when we talk about the state of police knowledge or showing up, or in this case, why was that relevant at all? I mean, what would be wrong with the officer saying, just like he did, I was just going through the Snapchats looking, as I don't normally do, and I see this guy saying he's going to carry his gun. And that sort of starts the investigation. Why isn't that just as relevant as, it doesn't, automatically need to show, well, that's why the police were focusing on the defendant. Well, he's on a Snapchat with a gun or talking about having a gun. Why isn't that good enough to tell the jury why the investigation started? It puts them in a position of being good law enforcement. Why did we need to hear about a shooting?
I think it gives important context to the jury, because again, the jury are here without being told, oh, there's a shooting going on. They know that there's been a shooting in the area, so that the jury are going to know that when they look through Snapchat and they see, oh, this guy's walking around saying, I ain't going out without my glizzy. It's not just a glib kind of, somebody.
Well, okay, now are you saying that the evidence was admitted to show why the police did a certain thing, or are you saying that the evidence was admitted to show why the defendant did a certain thing? In other words, carrying the glizzy, he did that because of the prior shooting, or is it because of what the police did?
Well,
which one?
Showing that the police, why the police would have, I guess, been on alert or whatever, they're looking through and somebody says something, the jury would have been told that, this officer knew this person, they knew that he didn't have a weapon, or that he didn't have a weapons license. And so I think it gives context of why, Officer Gracia is surveilling the outside of the house.
I think we're going to have to leave it there. Thank you
Thank you.
both. Well briefed. Appreciate your arguments, and the case is submitted. Calling our next case on the list, docket 24P1155. This case is partially impounded, so I would remind counsel not to refer to any proper names and not to any impounded materials during argument. We will hear first from Attorney Bartman. Nice to see you.
It's nice to see all of you. Thank you. Good morning. May it please the court. I'm Frederick Bartman, arguing on behalf of appellant. Primarily, I would like to argue that Commonwealth versus George left open the primary question that is before this court, which is whether the revised risk labels associated with a score on the static 99R test should be admissible in an SDP trial. And
So does the argument boil down to a straight 403 argument that the evidence is more prejudicial than probative?
I think it does. And I think that when you look at the permissible uses of the static 99R, it almost infers that result when you start to get into hyperbole about what a particular score means as opposed to actual data of known subjects. And the George court elaborated on that when it went on to say that we are reiterating that the percentage of known reoffenders for 5- and 10-year periods of time remain admissible in future SDP trials. And so all we've done with these revised labels in terms of the issue in George is change the language, change the vocabulary. Other than that, and it may be based on better empirical data, but that's not the real issue about these risk labels.
So why was it not sufficient with the judge's order that along with the risk labels that there be the qualitative metrics be used, that there be some more information provided to the jury? Why did that not cure any imbalance?
Well, because the data doesn't undo the prejudice, and also the misleading nature of these category labels in the first place. One of the qualified examiners referred to the nominal risk label for somebody who scored a 6 as the highest score, or the highest category, well above average risk, language such as that, and even like, and even the creators of the revised labels warned against using descriptive labels as opposed to the Roman numerals. But even the Roman numerals don't solve the misleading nature of these labels. The appellant in this case, by way of description of the creators of these labels, will not always be a 4B. In the templates by which he describes in the workbook, what a 4B label connotes is that, quote, with a dose of treatment and a couple of other possibilities that don't apply to appellant, but with a dose of treatment, somebody who originally is in this descriptive category, whether by language or Roman numeral, will eventually become a Roman numeral 3. And so...
Doesn't all of what you're saying go to the weight of the evidence, not the admissibility of it? Counsel's free to call their own expert to argue exactly what you're saying, or to testify to exactly what you're saying, or counsel can argue that. But we're talking about admissibility here.
Sure, but the admissibility has to be probative of the issue as it relates to this specific appellant. Is he likely to reoffend due to the forces of his mental abnormality or personality disorder that would drive him to reoffend?
In the old labels, the SJC held were, I'm paraphrasing, but confusing, ambiguous, lacking in real meaning. But my understanding is, and I think it's Dr. Hansen, said these new labels have actual contextual meaning. And I think, I've never seen an area of the law where we defer to someone more than one particular expert, but it seems that Dr. Hansen has spoken on this.
Sure.
And it seems that he suggests it may be fair game. Do you disagree with anything I just said?
I don't disagree,
Okay.
but I would expand on what you said, because Dr. Hansen then goes on to say that we're forewarned about, and I hate to use this word, but weaponizing this label to in litigation, as opposed to numbers, without really remembering exactly what
I
he
think
said.
he's also concerned about a one-size-fits-all application. And so context matters, facts matter, what each expert found and why
Sure.
matters in
Sure.
laying the proper foundation for the admission of these labels. Which begs this question for me. Why, in the context of this case, was it a 403 abuse of discretion?
Sure. Because in this particular case, what you had was somebody that had received a substantial amount of treatment, and there was certainly a debate about where he was progressing and where he was remaining entrenched in thinking errors that might cause him to reoffend. But the bottom line is he had many years of substantial treatment, had completed many of the courses, had advanced to certain levels. And again, you go back to a descriptive label that simply, by testimony, is the highest level.
But they explained how they arrived there, and why aren't the factors that you just cited ripe ground for cross-examination to point out the flaws in those conclusions? And to get back to Justice DeAngelo's question, why doesn't the argument you just made go to the weight of the evidence as opposed to the admissibility?
I suppose you could. I suppose you could make that argument, but even,
I don't want to make the argument. I want to know whether or not the judge erred or abused his discretion.
Sure. I don't think that it eliminates the bias and the emotional impact of hearing that this man scored a 6, which placed him in the highest category, well above average likelihood of reoffending. And so cross-examination could have chipped away at the prejudice that was evoked, but it doesn't eliminate what the jury has already heard.
Did the judges, I'm sorry, go ahead.
Isn't there some level of comparison, though, in any categorization? I mean, there is going, even, so say we made a decision that we didn't use the labels, and then you have an expert that's going to come in and say, well, he's a level 4A. They have to explain that somehow in relation to 3 and 4B.
Sure.
And assumably,
Sure.
the explanation is going to be there's greater risk.
Right. I think if there's greater risk by being in a particular category, that would be a very succinct statement for the jury to hear. Frankly, I don't think the Roman numerals should be admissible either. I don't think generalized statements about what the specific math means is probative enough to outweigh the prejudice that is evoked by it. And
So you might have a very different case, and I might be 100% in agreement if they just used the labels or they just used the numbers. But back to Justice Neyman, in this case, it was all explained as to why he came up with these numbers, what the factors were, which were all fodder for cross-examination. So I guess I'm back to, why isn't all of that admissible with the label when there's an explanation to it as to why they're that label?
Sure. The best answer I can give right now is that I don't think it eliminates the prejudice. The jury has already heard a damning description of the highest level possible, and making this amorphous comparison to all other sex offenders, that he's well above average compared to other sex offenders. This is about this one man, and the 5 and 10 year rates have specific mathematical empirical data to back it up. And similarly, saying that somebody who scored a 6 is 3.77 times more likely to offend than the average sex offender is completely not relevant to the elements of whether or not the Commonwealth has proven that this particular individual is likely to reoffend due to forces beyond his control.
Did Judge Bloomer's instructions place limitations on the jury's consideration of these nominal labels?
I don't remember that he did. I honestly haven't read his instructions in the recent weeks leading up to this argument, but I don't recall that he did. And I'd also like to comment about the 20-year extrapolated rate, which doesn't have any data backing it up other than actuarial, mathematical laws that allow for, whether it's insurance companies or legal malpractice companies or people that are doing this kind of work to make these kind of determinations. And when you look again at the underlying workbook and information provided when they discussed the 20-year extrapolated rate, one of the things that they point out is that this is capturing persons that have had a delayed relapse. And that suggests that there was a period of time where they had control. And it makes all the more prejudicial and irrelevant whether or not, where he stands in the projected calculus at a 20-year period of time. And in fact, the framers of the static 99R and this projected rate refer to it as a lifetime rate. And if you start to apply that evidence to a Section 9 trial about whether or not now appellant is suffering from these forces that are going to cause him to be likely to reoffend, we are really getting into preventive detention territory, something that obviously is constitutionally prohibited and something that I think they went through a lot of trouble to protect against in the Section 12 and Section 9
Counselor,
trials.
your time is running out, and I just wanted to ask you a question about your other issue. Was the social worker able to testify about the plans that were going to be in place if released?
Yes, she was.
So why is it prejudicial that the report itself was not admitted?
Because when the jury gets into the deliberation room, they have a CAB report, they have 2 qualified examiner reports. Both of these, all 3 of these reports make reference to the appellant's release plan and reject it as being sufficient to protect the public were he to be released. And then the jury is going to think about, well, what were all those different things that she testified about? And it's an imbalance to think that they would have been able to do that without referring to the report itself.
Does it matter does it matter that I believe the reports that were admitted into evidence were from experts and she was not qualified as an expert?
I don't think so, Your Honor, because the issue is not expertise. The issue is a balance in the evidence.
Do you have a case that supports that? Your time's up, but please answer the question.
Yeah, well then, no. I don't, and thank you very much.
Thank you. Let me just make sure. Okay, nothing further. Thank you. And we'll hear from Attorney Murray.
Good morning, and may it please the Court. Mary Murray for the Commonwealth. The petitioner has given this Court no ground to disturb the jury's verdict in the ultimate judgment below. Turning first, and I'll start with the last issue you addressed with the petitioner, Ms. Patz was not qualified as an expert. She was not identified as an expert. The parties listed her on the joint witness list as a fact witness. Under Reese, the SJC's 2003 decision in Reese, it might be 2002, excuse me, decision in Reese, the court said that the catch-all provision for other evidence that's admissible is limited to evidence that is admissible under the rules of evidence. Her post-release memo was nothing but inadmissible hearsay that contained lots of unattributed hearsay, and it was not admissible on any basis.
Under our rules of evidence, just because somebody's an expert, the report doesn't get admitted. It's still hearsay.
Well, except in Chapter 123A.
So it has nothing to do with the fact that the social worker wasn't an expert. It has to do with the fact that that's not statutorily an exception to the hearsay rule.
That's right, or any other exception to the hearsay. And the SJC took pains in Reese to say that that catch-all exception in Chapter 123A applies only to evidence that would be independently admissible under the rules of evidence, and there is no ground for that document to have come in.
So that's where I'm missing your argument. Even if the social worker had been qualified as an expert, under 123A, the report still wouldn't be admitted under your argument, correct?
No.
Why
If
not?
if it had been an expert report, then the report would have been admissible, subject to redaction, of course, for inadmissible matter, under the Santos decision, which says that the petitioner's expert reports are admissible in evidence on the same basis as the qualified examiner reports. So, for example, things that, I'll take an example, the penile plethysmograph, which is not admissible under this court's and other decisions, would be redacted. So a defense petitioner's expert report, had it been an expert report, would be admitted under Santos. But Santos has no application here because it was not an expert report. She wasn't offered as an expert, she didn't testify as an expert, and she wouldn't have been qualified to give an opinion about the sufficiency of that release plan based on whatever her area of expertise. It wasn't in the field of assessing sexual dangerousness. And that was the basis for the Commonwealth's original motion to exclude it. And then, of course, the parties did identify her as a fact witness. And I might mention the petitioner has waived this issue because he did not object to the Commonwealth's or oppose the Commonwealth's motion. There's been no provision to this court of the transcript of the pretrial conference, so there was no objection, and he didn't try to offer it at trial. So you'd be reviewing this under a substantial risk of miscarriage of justice, and there is none here. Because she was allowed to testify. The report was provided late to Dr. Bell, one of the QEs, after he had written his report, but he considered it before the trial and said it didn't change his opinion and it wasn't sufficient. Dr. Callistra had received it before her report was finalized, and she said both in her report and testimony, she was the other qualified examiner.
You're saying the issue about Patz's written report was waived?
Yes.
What about the motion in limine?
The Commonwealth moved to exclude the report. The petitioner did not oppose it, and the petitioner, I don't believe, has provided this court with the pretrial, the transcript of the pretrial hearing. So we argue that it is a waived issue.
Can you answer my question about whether or not Judge Bloomer provided any instructions that guided the jurors as to how to consider the nominal labels?
With respect to the static 99, there was not a specific instruction on how to apply that evidence. What he did require and what the Commonwealth did do was when the static 99 information was offered, the Commonwealth was required, and the Commonwealth did explain the score, how the petitioner arrived at the score, the limits of the static 99 are, the label, the risk level, the percentile rank, and also an explanation of what those statistics mean, meaning that it is a reflection of the number of men, because it's all males who are the subject of this, the number of men in a particular sample, in this case the routine sample, who were either charged or convicted of a new sexual offense within 5 years, 10 years, or the projected 20-year rate upon release into the community if they had been incarcerated, or from conviction if they had not been incarcerated. A lot of the sample had not been incarcerated. They were given all of these metrics, and Dr. Hansen himself and the other developers in their evaluators workbook, which you have in our supplemental record appendix, said that providing all of these metrics may result in the best ability to differentiate between individuals, that you shouldn't pick and choose as an evaluator which metrics to give, and that reporting all the metrics is often the least biased and most helpful approach. And the difference here, the new labels, the revised labels.
Well, he's talking about, I think Dr. Hansen there is talking about the uses of this by the experts as opposed to the uses of it in front of a jury.
No, I would respectfully disagree with you, Justice Neyman, because they're, in the evaluators workbook, they're talking about communicating the metrics to people who would be using this information, including fact finders. And they
Does it say that? Does it say including
yes,
fact
I believe
finders?
they talk about communicating it to people who are making decisions. And they're certainly well aware that these are used in trials. That you shouldn't pick and choose which ones to communicate. And they encourage presenting all the risk communication
Where in the
metrics.
record can I find that? What page range, please? What volume and page range? If you don't have it right now, we'll find it.
It's in the supplemental record appendix, so that's where the page is, but I referenced it in our argument.
Does that include the 20-year rate?
I beg your pardon?
Does that include the 20-year rate?
The 20-year rate,
When he's saying to include all of the metrics, does that include the 20-year?
I don't think that they differentiate between the 5, 10, and 20-year rate, but I do want to address that. It's supplemental record appendix by the Commonwealth, page 34. So with respect to the 20-year rate, the petitioner agreed that all of the rates should come in the petitioner's own filing, which is reflected on page, record volume 1, page 87. He agreed that the score and the related rates could come in. He certainly was aware, because in that same filing, the petitioner's attorneys referenced the 5, 10, and 20-year rates, and he agreed that they could come in. So they came in, and the reason there wasn't any discussion anymore about the underlying research for the 20-year rate is because he agreed they could come in. Had there been a challenge, we would have discussed it, but the research on which those 20-year rates are based is contained in the evaluator's workbook at the end. It's cited at the end. And there is no temporal limitation in Chapter 123A about when the reoffense can occur. And in fact, this court in Bradway in 2004, Justice Kafka wrote for the court that there is no requirement of showing of an imminent danger. And not only does it show, does the 20-year rate account for delayed relapse, but also delayed reporting. Because not all sex crimes come to the attention of law enforcement at the time that they are committed, for whatever reason, particularly with child victims. So it accounts for both delayed detection and delayed reporting and delayed relapse into the behavior. Now, with respect to the revised risk category, there is no error in its admission here. First of all, these differ from the prior labels, the earlier ones deemed problematic in George, because they are specifically tied to a mathematical term, average. The jury was told, and they have it, and you have it in Dr. Callistra and Dr. Bell's report as well, that the average sex offender in this group of routine individuals is detected at 5 to 15% over 5 years. They received information about, and that's in the routine sample. It can be found at the record appendix, pages, volume 2, page 144, and 211. The jury was also told that they're not required to accept the expert opinion in whole or in part. So while it didn't specifically address the static 99, that came in through expert opinion, and that certainly, they were not required to do it. The petitioner has cited no authority in no case that has ever held that the revised risk category or the other metrics, the percentile ranks and relative risk ratios, are inadmissible.
The SJC has not weighed in on that yet, correct?
They haven't.
And there are no published opinions which have weighed in on that, correct? These are all Rule 23s.
Or Rule 128.
Or Rule 128.
Depending on how old they are, including at least one member of this
I was
panel
here when we
has
had
been
Rule
on.
128s. My
Back in the
colleagues,
old
maybe
days,
not.
for those of us who've been around a little while. Even if the court were to determine that admitting any of this information was error, in light of the overwhelming strength of the Commonwealth's case, 7 psychologists opined that the petitioner was sexually dangerous. The petitioner, although awarded funds and has no burden of proof, but he offered no contravailing expert opinion. And with respect to his performance in treatment, the record shows and the testimony showed that the petitioner, although he had passed a large number of classes and is quite intellectually bright, was incapable of internalizing it, including about the way he talked about his victims, that they encouraged, solicited, promoted the sexual misconduct, invited the behavior, his statements in his treatment of females in the facility, his behavior in treatment, his dropping out of treatment on the eve of the trial, and all of the other things identified in the Commonwealth's brief, given the overwhelming strength of it. And the court's instruction to the jury that they were to be completely fair and impartial to decide the case without any emotion or prejudice, and to base their verdict on the law and the evidence and the facts as the jury find them and nothing else, there can simply be no showing of prejudice here. So for all of those reasons, the Commonwealth asks the court to affirm the judgment below. And unless there are any questions, the Commonwealth will rest on its brief.
Seeing no further questions, I'd just like to thank counsel for both parties. Well argued, well briefed, and the case is submitted.
Thank you.
And calling our final case, docket 24P1366, Francis v. ABBAN, or ABBAN. We will hear first from Attorney Gill.
Good morning, Your Honors. May it please the Court?
Good morning.
My name is Danielle Gill, and I represent the appellant Thomas Francis. I would like to start the argument by addressing an important issue of the timeliness of Mr. Francis's MCAD complaint.
Okay, before you begin with that argument, I think we have some housekeeping matters to deal with. Specifically, we have a motion that has been referred to the entire panel on whether or not to consider the late filed record appendix. So this is a summary judgment case. Our review is de novo, and we review the statement of material facts, and then we have to go see the citations in the statement of material facts to see if the representations are accurate. So why the late filing, and tell us why we should allow the motion.
Thank you, Your Honors. I do apologize for the late filing. Ultimately, in preparing the appendix and the materials to be submitted therein, an error occurred where I erroneously did not include the summary judgment exhibits. That was entirely my error, and ultimately was compounded by technological issues, which contributed to the error, but ultimately erroneously were not included. However, they were a great deal of the record below. And as such, immediately upon realizing that these materials should have been included, I contacted Brother Counsel and explained that I would be filing a motion to seek to late file these documents and provide a supplemental appendix. These materials, as I stated, were provided below to the lower court, and we do believe that they are important to your review. I do apologize for the late submission and delay.
One more housekeeping question. Are you acknowledging that the sexual harassment claim stands on a different footing than the age discrimination claim? In other words, are you conceding for purposes of this argument the age discrimination case is out the door and you're arguing solely the sexual harassment claim?
Yes, Your Honor.
Okay.
With the exception that the retaliation regarding his age complaints still survives.
The age discrimination case is
separate.
And it's out. We don't have to consider that.
Yes, correct.
Okay, thank you.
Thank you, Your Honors. However, his sexual harassment complaints, we do believe, were timely filed. And in looking to those filings, we would point you to the proposed supplemental appendix by the plaintiff to review many of the materials that were filed in the MCAD. Most importantly, I'd like to point you to the document that was filed in the MCAD. I'll start by saying that Mr. Francis originally went to the MCAD on July 18th of 2012. And when he went to the MCAD on that day, he did submit a compliant filing, which can be found in the supplemental appendix. And that compliant filing, excuse me, can be found at page, it's part of Exhibit 20 to the department's motion for summary judgment, and it can be found at page 1545. That document, again, was filed on June 18th of 2012. Several days later, Mr. Francis went back to the MCAD in person, and he submitted the document that is found at page 1547, which is titled Sexual Harassment Retaliation, and for several pages goes on to explain in significant detail the discrimination, harassment, sexual harassment that he suffered at the hands of Ms. Deborah Driscoll, as well as other colleagues, due to their encouraging of the harassment following his complaints of the sexual harassment. And that document, he was under the impression, was filed and submitted.
So what do you say to the email that he received saying that he did not file it correctly and providing him with the mechanism to do so, which he did not do?
Thank you, Your Honor. What I would say to that is I would ask that the court also review within that email, the MCAD investigator actually points to the fact that if you look on page 1327, which is part of the original appendix, she does indicate, excuse me, all I know is that the next correspondence I received from you was a request to amend your complaint on September 10th, 2012, to add 5 individual respondents to your claim. The claim was amended, and these individuals were added on October 10th, 2012. What's interesting about that, Your Honor, is that if you go and look at that document, and that document can be found in the proposed supplemental appendix at page 1557 through...
You're using page 1557, but the supplemental appendix, at least that I have, is numbered 10001 through 63.
I apologize. I believe that that's the department, the appellee's supplemental appendix. I was referring to the proposed
appendix, okay.
Yes, the proposed appellant supplemental appendix.
Can you give me those pages again, please? Thank you.
They are pages 1557 to 1558.
Got it.
And again, this is part of Exhibit 20 that the department submitted in its motion for summary judgment. If you go to that page, which is what the investigator is referring to when she states that he did successfully amend his complaint at that time, if you go to that document, it actually has, again, very clear complaints about sexual harassment and the actions that he suffered as a result of the sexual harassment and the conspiracy among his sexual harasser and the other supervisors that he is naming to retaliate against him for complaining of her sexual harassment. So it's interesting,
The
Your
fax
Honor,
date on that is January 30th, 2014.
I apologize, Your Honor. It's part of a submission that was made on that day.
Right.
But the document itself, which is, again, it's part of, so Exhibit 20, which I believe begins at page, document 20, which begins at page 1542, is a fax submission on January 30th. But it refers to, for several pages, about 20 pages, several other documents that were previously submitted. And one of those documents at 1557 is a document, yes, there's a fax at the top that says January 30th, which is when it was again resubmitted. But the date there is September 3rd, 2012, if you look at the memo on 1557. And that's the document that Ms. Hickey in her email in January refers to as 5 individual defendants being added. So when she indicates that the sexual harassment claims did not come up or were not properly added, I think it shows that there was significant confusion in the MCAD and possible misleading by the MCAD investigators about what claims were actually added. Because if she's saying in that email that He hadn't properly amended to add sexual harassment claims, but he did properly add to amend these 5 supervisors. The document adding the 5 supervisors is replete with complaints of sexual harassment.
The MCAD, as I understand it, has specific rules for the filing of a complaint and for amending complaints. Does this document at proposed supplemental appendix 1557 comply with the MCAD rules?
Yes, it's my understanding that it does, and that's why that document was allowed to amend his complaint, which she indicates allowed for 5 individual respondents added to the claim.
So if I
according to her email.
cross-reference the MCAD rules for amending a complaint, I'm going to see that this document here complies with their regulations and their rules.
That's my understanding, Your Honor, at
Well,
least for the rules at that time. For instance, I think now e-filing and e-signatures is acceptable, but back then you needed to actually sign the document. And you'll see on 1558, he did sign this document in comparison to, unfortunately, the document that was submitted on July 23rd of 2012, just, 2 months prior.
And your argument is that this document, because it references sexual harassment, is sufficient to add a complaint, to amend the complaint to include sexual harassment?
That's one argument, and in the alternative, Your Honor, if Your Honor's not willing to agree that that potentially does sufficiently add the claim.
Is to look at page 1327.
Either 1327 or the documents 1547 through 1550, because that complaint, the one submitted July 23rd, that one is unsigned, and I believe that that was the issue with the compliance with the MCAD regulations. Unfortunately, again, this is the document detailing the sexual harassment that he suffered. Apparently, the MCAD did not accept this as a proper amendment because it was not signed. On the last page, 1550, it was not signed.
So just so I understand your argument, on the timeliness argument, you are saying that we should be directed to your proposed supplemental appendix at 1547 to 1558 and to look to 1327 of the original record appendix, and that is the substance of that backs your argument.
Yes, Your Honor, but I would also note that it's important to look at what the actual date for when the 300-day trigger starts. And we would actually assert that it's a continuing violation, which is what we argued below in our memorandum in opposition of summary
Understood.
judgment. We would argue that it's a continuing violation that actually began on the day of his termination, which was July 13th of 2013. So we would argue that all of these complaints, even the one in January of 2014, is timely.
That's July 13th of 2013.
Wasn't there a document that says that an MCAT investigator said on July 24th, 2012, you submitted information about sexual harassment and additional acts of retaliation?
Yes, Your Honor.
Where is that in the record?
That is at page 1327 through 1329. And that, Your Honor, does refer to the document at 1547, or beginning at 1547. And I would also...
No, I think what Judge D'Angelo is asking, correct me if I'm wrong, 1327 to 1329 is the email. He's looking for the underlying documents referenced in the email.
I apologize. That document, Your Honor, is 1547.
That is back to 1547 to 1558.
Yes, Your Honor. So I would again point out that under a de novo review, the argument that we made in the lower court that this was a continuing violation, all of these MCAD complaints were in fact timely. I would also like to point out, Your Honors, that in the event that you're not willing to find that it was a compliant, timely violation, we would argue that equitable estoppel applies. This email found at 1327 through 1329 does reflect there is significant evidence that in a light most favorable to the plaintiff, which is what the Superior Court should have applied, that the MCAD does acknowledge that there was significant there was excusable neglect and potential misleading by the MCAD. In fact, the MCAD actually indicates having 300-plus cases on my docket can make it very confusing at times. Clearly, there was confusion during the course of the investigation, and I apologize if it was due to my error.
So you're saying that wasn't intentional misleading?
I'm not sure if it was intentional misleading, but I think that there was misleading by the MCAD. She also noted, "I'm sorry if this was not clearly explained to you during the intake process." But certainly, viewing it all together couples with the fact that clearly Mr. Francis believed that he had made a timely complaint. So we would ask that you reverse the summary judgment in the lower court and permit him to move forward on those complaints.
Thank you. Well argued, counsel. Thank you.
Thank you, Your Honors.
Good morning. May it please the court, Alan Forbes for the defendant, Suffolk County Sheriff's Department.
Morning.
The department's position is that the plaintiff has waived any of the argument that this panel just heard. At the summary judgment stage, the plaintiff submitted a brief. It's in the appendix at 1308. And it's page 4 of the plaintiff's summary judgment brief, where the statement is, in July of 2012, his attempts were effectively thwarted when he was told that the office was about to close and that he wasn't using the proper procedures to file a complaint. Further down on the same page, Francis's brief says, Francis concedes that he should have maintained his position and pushed forth his official complaint with the MCAT at the time. Francis describes on the same page his decision to give this up as a lapse in judgment. The brief explains essentially on this page that Mr. Francis was apparently in an upset state. He says he was, in the brief, he was unjustly harassed by Driscoll, unfairly ridiculed, and that's what led Francis to give up his initial complaint. He gave up the complaint. So I would suggest to this court that at the time of summary judgment, Mr. Francis had a view, or the plaintiff had a view of equitable tolling that was not compliant with the case law that's developed around that principle.
Let's go before we get to equitable tolling, let's go back to whether or not the filing was timely or not, the amendment was timely or not. So our review is de novo, which means we have to go to the summary judgment record.
Yes.
And do you agree, assume, without deciding, because we haven't decided, so just assume that we allow the motion to include the proposed supplemental appendix, okay? Would you agree that the documents at pages 1547 to 1558 that Attorney Gill just pointed out to us were properly in the summary judgment record before the judge at the trial court?
I assume that they are. Yes.
Okay.
My answer is yes.
So if we allow the motion to allow the supplemental appendix, we have to consider whether those documents at 1547 to 1558, plus the email at 1327, let's set aside the continuing violation argument for right now. We have to determine whether or not that demonstrates that the filing was timely. And not just timely, the amendment, but also in compliance with the MCAD regulations in effect at the time and their rules. So my question for you
Yes.
with that big windup, and I apologize for the long question, but if you understand, I've given you context, and now here's my question. Why is she correct or incorrect? In other words, why do the documents at 1547 to 1558 not show compliance with the MCAD regulation then in effect?
So the documents talk about Ms. Driscoll, they talk about sexual harassment, but it's not a signed complaint within the meaning of the CMR. That's the department's position.
It's not a signed complaint within the meaning of the CMR. Why? You just said it's your position that it is not a signed complaint within the meaning of the CMR. And my question to you is why or why not?
Well, I suppose that it would be.
Okay. So does our analysis here come down to, on the issue of the timeliness of the amended complaint, come down to whether or not we allow the motion to supplement the
No, I don't think
appendix?
it does, Your Honor, because although the panel's standard of review is de novo, we're still talking about the issue of waiver. What was the argument below? And an argument raised for the first time on appeal is waived.
Okay.
So, okay, that begs the question. The document at 1547 through 1558, putting aside the waiver argument, and I know you're not putting it aside, but
Neither are we.
I understand.
just for this question,
I understand.
was the complaint timely filed?
I must concede that it is.
Okay, thank you. Now, you can go forward, I guess, on the waiver.
Please.
So it is the department's position that the plaintiff's position on appeal is directly contradictory to what the plaintiff said in the trial court. If we go to Mr. Francis's affidavit in support of the summary judgment, it is the supplemental appendix at page 38. This is the plaintiff's affidavit in opposition. Mr. Francis states the following at paragraph 25.
And what page is this again? I apologize. Supplemental appendix.
I have supplemental appendix page 38, Your Honor.
Thank you.
Mr. Francis says at paragraph 25, the amendment I made to my MCAD complaint included an inadvertently unsigned memo dated July 23rd, 2012. The position he's taking now is absolutely in opposite to what he took in the trial court. And again, although the de novo review standard applies here, the argument is waived. We're looking at what the motion judge had before him at the time, and what he has before him is a statement that Mr. Francis knew he wasn't filing the complaint properly. We know that from the summary judgment brief, and we know that he made a choice not to file it. That's further buttressed by Exhibit 31 to the summary judgment motion, 1325, where the MCAD investigator writes to Mr. Francis, I contacted you, and this is a reference to July 24, 2012, to instruct you how to file an appropriate amendment. And you stated you wanted to hold off on filing any motions until the respondent decided if they wanted to mediate. And then further on, she says, the next communication I had with you is in September about modifying the complaint. So the plaintiff has now taken a position completely in opposite to what was going on in the trial court. It's waived.
In the trial court at the motion for summary judgment, the judge in a margin ruling said that there was no evidence that the plaintiff failed to file the complaints with the MCAD within 300 days. That's what the judge's margin endorsement said.
There was no evidence.
She says that the discrimination claim was barred because the plaintiff failed to file complaints with the MCAD within 300 days. But now we know from the if we allow the supplemental, there was a document that you say was timely filed.
Yes.
So how is that waiver if the judge made a mistake in documents that were filed?
Well, in part because of the anti-ferreting provisions around Superior Court Rule 9A. The plaintiff can't simply take a stack of documents and dump them on the bench and say, Judge, it's in there. There's nothing in the plaintiff's affidavit that says there was a timely filed, I, Tom Francis, timely filed a complaint with MCAD. And in fact, the briefing says, I decided not to.
Right, we're bound on summary judgment by what's in the statement of undisputed facts, in the plaintiff's counterstatement, and the citations in the record. That's what's going to dictate our determination, because that's not waived. What is in there and what is argued in there is not waived.
I understand.
So we have to look at that document, ensure that 9A was complied with, and then see, again, what is admitted, what is denied, and when there's a denial, does the record support the denial or not?
I understand.
So that's where we're at in terms of waiver. Okay.
Understood. If there are no further questions on the MCAD filing, I would move on to the Rule 403.
Please.
At the outset, there is a motion to strike outstanding on this issue. The motion to strike concerns is asking for the court to strike Section 2 of the plaintiff's brief and a portion of the statement of facts. And the basis for this is as follows. At trial, the plaintiff attempted to get into evidence a former employee, Joseph Sissia, who claimed that he was sexually harassed and then retaliated against because he complained about the sexual harassment. There were two sidebars that took place during the trial.
And the judge excluded it under Rule 403, said it would lead to confusion, and those documents were not marked as for identification at trial.
They were not marked at all, and they were not. There's some lurid discussion of the Sissia complaint in the plaintiff's appellate brief. None of that material was before the trial judge. All that he knew, all the trial judge knew, was that the plaintiff had an email discussing Sissia. Should we terminate Francis with the same letter we used for Sissia, and that there was a civil complaint filed. So that was not made part of the record at trial. It has no place in the record before this court, because the rule says that the record on appeal is the record from trial. And so to just tuck extraneous material into the record appendix is highly misleading. And it is not what we can't fairly judge the trial court's decision based on something that he did not.
The motion to strike has been again referred to the panel, so we will have to make a decision on that as well.
Okay. And then further on, even without considering the motion to strike, we have the Rule 403 determination that the trial judge made, which was that the fact that Sissia made a complaint about harassment and retaliation had at best relevance that was minimal. And weighing that against the prejudicial effect, risk of confusion to the jury, all of that, the court found that it was not relevant. The department pointed out that there had been roughly 50 people administratively terminated by the department, and that if the plaintiff were to be permitted to introduce evidence of the Sissia termination, then the department should have been able to put in evidence of the 50 or so people who had been administratively terminated. And the judge considered that an enormous expenditure of time and determined that it wasn't going to come into evidence. And under the abuse of discretion standard, that was not a unreasonable alternative for the trial judge to reach. And if there are no further questions, I'll just stand on the briefs at this point.
Seeing none, thank you. I'll note for the record that counsel was also, for both parties, was trial counsel. It was a well-tried case. Your clients were well represented, and I appreciate your arguments on appeal as well, and the case is submitted. Thank you.
Thank you.
I'd like to thank the clerks, court officers, and staff, and that concludes our session.
Court already